In this video, we're just going to talk a little bit about liability and risk management and what that has to do with financial management. The bigger liability stuff, the more detailed stuff you cover in that class. So this is going to be a brief overview of that, and then we're going to connect it to financial management. So some big picture terms. When we talk about liability, we talk about legal versus civil. Things that are in the legal realm, i.e. against the law, you go to jail for, or can go to jail for. Things that are civil are wrong committed against another person. You don't go to jail for those, but you'll have to do some sort of restitution. There's a different standard for each of these. For a legal, to be found guilty in a legal trial, it must be beyond a reasonable doubt. In a civil trial, it must be due to a preponderance of the evidence. So it's a lower standard to get a civil conviction than a legal conviction. For our purposes, we're mostly concerned with civil cases here. In that realm, we talk generally about two types. One is a tort, and the other is contracts. So a tort is a civil wrong done against another person that caused them some sort of harm. And a contract, we're just talking about violations of contracts. In civil cases, you generally have two types of damages that are awarded. One is called compensatory. This is simply a makeup. You lost $3,000 as a result of the wrong I committed against you. I have to pay $3,000. The other is punitive, which is to teach you a lesson. It's punishment. So even though it was only $3,000, I need to teach you a lesson. So you're going to have to pay back $20,000. When we talk about being negligent, in a civil case, there are three basic defenses against it, and these are particularly relevant in the parks and recreation world. One is the assumption of risks. That is, the plaintiff, so the person suing, knew the danger and they voluntarily subjected themselves to the danger. If you sign up for to go bungee jumping, oftentimes you're signing some sort of an agreement that states you know that there's some risk to that. If you play football, chances are you know there's some risk to that. The other is comparative negligence, and this really depends on the state and how valuable this is. But this says the plaintiff is more responsible for the damages than the defendant. Yeah, the defendant did something wrong, but really it was because the plaintiff was being an idiot that caused the damages. And then contributory negligence, again, depends on the state, but this is basically partitioning out the blame or the fault. So the plaintiff may be partially responsible. So here's a slide about assumption of risks. It says you hit Bobby in the head. Yes, but he assumed the risk of injury. So that's often a defense in parks and recreation liability cases, that the plaintiff knew the risk and they knew something was going on. Risk management, again, you talk a lot more of that in the liability class, but just really quickly, we often talk about this, the risk management process. You identify the risks. What are they? You assess them. How bad are they? You evaluate them. How bad are they, and what's the likelihood of them? And then you manage and plan for them. We talk about three different types of risk control strategies. We avoid it entirely. That bungee jumping trip is too risky. We're not going to do it. You transfer that risk, often through insurance. I'll talk about in a second. And you reduce the risk. Okay, bungee jumping is dangerous, but we're going to take all these safety precautions. So what does this have to do with financial management? Well, the bottom line is civil cases. If you lose a civil case, you're going to have to pay money to do that, sometimes a large sum of money. So you are, by managing your risk, you are also managing your finances. So how do we finance that risk? So again, we'll talk about a couple of different ways. One is we retain the risk. We realize it's there, but we're okay with that. In this case, we need to make sure we have money to pay any damages as a result of civil cases. One is pay-go. We talked about this in capital financing. This is, you pay for it as you go along. So you have those reserves, or you don't have the reserves, sorry, but you've got enough money, you can pay for it. The other is an unfunded reserve. This means you don't technically have the money available, but you make some sort of notation that it may happen. Another is a funded reserve. This is you set aside money. You say this is our emergency fund in case something bad happens. Large organizations, large counties will do this. Arlington County, Virginia, is a fund reserve, uninsured fund reserve. So basically, they have their own insurance plan. They set aside money. And then finally, you can get self-insurance, which is basically a fund reserve, and joint pooling, which means you work with other organizations to have a pool set aside. You can also transfer the risks. Insurance is the most common way to do this. So you're still retaining some risk, but if you're losing a civil case, you've got insurance to back you up. Releases and indemnification agreements. These are basically waivers. This does transfer some risk. They're also potentially problematic in a civil case if you're negligent. The fact that someone signed a waiver is generally not going to help you. And then you can use a contractor. In that case, the contractor is taking on some of the risks. There are laws in place related to municipal immunity. Again, we're not going to go into the details here, but just so you know, if you're working for a government agency, you do have some immunity protections that are legally built in. So that's financial management and liability in a super quick nutshell.